Well, hello, hello, hello. Welcome, everybody. Welcome to the show. It is January 2nd, 2026. And I hope that everybody had a wonderful New Year's. I kind of rested a little bit, but we are here today, as I am every day. And of course, schedules are going to change. Um, but, I want to make this channel a go more than I wanted the technology channel. I'm more passionate about doing this technology channel than I am. I mean, I was passionate with technology channel for a long time, and then when we got attacked, that was it. I lost that passion. Now I'm talking about courts and court cases. Excuse me. And I'm more passionate about doing this because it's less stressful on me. So today is Judge Aaron Gauthier. Gauthier. I like this judge too. He don't play. So let's get started with this. Oh, and by the way, anybody that's a new subscriber to this channel, thank you very much for subscribing to this channel. If you like this content and you are not a subscriber to this channel, please do me a big, huge favor and subscribe to this channel. And let's make this channel grow and make it bigger and show the haters that we don't need them. So let's get on with Judge Gauthier. So let me go back here and make this bigger. Why is it not making it bigger? All right. And don't get me wrong. I'm still here. I'm just having to watch for ads. If there's any ads, I can skip the ads. But I'm still here.
Mr. Funk, let me see. Good morning, Mr. Funk.
Good morning, sir.
All right, I'm looking for Mr. Harris zooming in here. All right, so it says iPhone. Sir, what is your name?
My name's Allie Peters. I got the link to have a Zoom with against Ryan Peters.
In a divorce case?
Yep.
You have the wrong Zoom number. This is Judge Gauthier in Presque Isle County on a criminal docket today.
Okay. All right. Thank you.
Yep. All right. All right, sir, what is your name? It says iPhone.
Ricardo Harris.
Okay, very good. So we have People v. Ricardo Harris. It's file 25-93380FH. Counsel, you want to state your appearances beginning with People?
David Funk.
On behalf of the people.
Sorry about that. Dave Funk, P26715 on behalf of Mr. Harris.
All right, and Mr. Funk, have you had a chance to review the charging document with your client?
Yes, sir.
And do you or he wish to have its allegations read into the record?
No, sir. We'll waive the reading of it.
And how does he wish to plead to those charges?
Not guilty.
Do we have that file? I don't have a copy of the information yet. Has the information been filed?
To my knowledge, it has, Your Honor.
Yes. See the complaint.
I have a dated copy for the 6th, Your Honor, or 26th, Your Honor.
Of the information?
Yes, Your Honor.
Do you have a copy of the information, Mr. Funk?
Yes, sir, I do.
Okay, it's not in the court file. Can you present one? I can't arraign somebody on an information that the court lacks.
My apologies, Your Honor.
So everybody's got it except for the most important part. The court's got to have the document to proceed here. All right. All right, we'll enter a plea of not guilty on Mr. Harris's behalf to 2 counts of assault by strangulation, count of child abuse 3rd degree, and 2 counts of domestic violence. Is a forensic center referral requested, Mr. Funk?
No, sir.
Okay, what would be the estimated length of trial?
No more than a day and a half to 2 days, Judge.
I would agree, Your Honor.
Okay, very good. Funk appropriate for docket call January 5th at, say, 10 a.m.
That's fine, Judge.
Okay, and do you want Zoom appearances to be allowed for that hearing?
The defense would, yes.
Okay, any objection, Mr. Wirgo?
No, Your Honor.
All right, so Mr. Harris, Mr. Funk, the docket call in this case will be scheduled for January 5 at 10 a.m. And Zoom appearances are allowed but not required then. All right, anything else from the people?
No, Your Honor.
From the defense?
No, sir.
Okay, have a good day, Mr. Harris.
Thank you.
You too, Judge.
All right. All right, good morning. What is your name?
Good morning, Brady Fisher.
Okay, so Mr. Vogler, this is People v. Brandy Fisher, file 21-93 or 93178FH. Here for docket call, and also we have the motion to reinstate bond and amend the conditions. In terms of the docket call, do you know what our status here is of the case?
Yes, I do, Your Honor. There's another case right now pending in the district court. There's been a plea offer made to us that basically wraps this case into that case.
Okay.
So we're not really ready to proceed here.
So you want me to continue the docket call to the January 5 docket?
Yes.
January 5 at 9:40 a.m. And as to your motion with bond, go ahead.
Judge, I don't have a whole lot more to add other than, as I mentioned, there is a case in the district court. That is a felony case also. Her bond set in that case is $10,000, 10%. I think the most important thing, I recognize she was gone for a number of years here, but my client did turn herself in on court bench warrant, came up here with the aid of her sister, turned herself in. She is involved in the family court in Macomb County. She has an attorney there, Susan Dunn. And in that particular case, it appears like the Department of Health and Human Services would like to place, in fact, they would like to place the children with her. But I think the fact that this bench warrant was outstanding in this case was preventing that. So she executed a delegation of parental authority The children are placed, I believe, with a relative, if I recall that correctly. She has a residence in Detroit where she's been residing this time. During the past 4 years, there's been a number of times where she has turned herself in downstate. Not that. One of the things too, I think is important is the fact that back in September of 2021, she completed a 6-week anger management course and has engaged in rather extensive counseling in Centerline, Michigan. And I think that at least goes to it speaks towards the allegations in this case.
Okay. Thank you, Mr. Vogler. Mr. Wargo, people's response?
Your Honor, I would note that defendant will be facing there as part of our offer. There's potentially not doing an absconding charge that would be forthcoming. If we're unable to resolve, I would be seeking remands to file felonious assault and child abuse second charges. Your Honor, this is a very serious case, and as to the allegations, Ms. Fisher is waiting in the wings for the kids. I'm pretty certain that once the department becomes aware of the specifics of the allegations in this underlying case, that's just not going to be an option. Nothing else, Your Honor.
So you're opposed to amending the bond conditions to remove the no contact? Am I hearing that right?
Yes, we'd be opposed to removing those conditions as well as any reduction in bond, Your Honor. She's facing a lot here.
Well, I mean, what I have in front of me is 2 counts of a 2-year felony. The defendant had posted a $10,000 10% bond back in 2021 and then didn't appear. And a warrant was issued. She did turn herself in on it now 4 years later, so I revoked her bond pending this hearing. There's another felony pending in the district court, but it sounds like from both the people and the defense that there's a possible global resolution of the whole case. And I think looking at all of the factors of 6.106F, I mean, I think it might be appropriate to set a bond rather than leave bond entirely revoked here. I would note that a $10,000 10% bond was insufficient to secure Ms. Fisher's appearance before. So a personal bond would certainly be insufficient to secure her appearance. The court will set a $50,000 cash or surety bond with the same conditions. And at this point, Mr. Vogler, I'm not going to amend or remove the conditions. I just don't know enough about the underlying facts here. And I don't know whether the department downstate that wants to place the children with her is aware of these facts. I mean, if it may be that removing those conditions is going to be entirely appropriate, but I can't be confident of that today. So I'm not going to remove those conditions, but I will set a bond. And then we'll be next January 5th at 9:40 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Okay. All right. We'll see you then, Ms. Fisher. If you do post the bond, you have to be in person in court on January 5th at 9:40 in the morning.
Thank you.
See Mr. Williams and Mr. Harimoto on Zoom. Good morning, Mr. Williams.
Morning, Your Honor.
All right, up next, we have People versus Alex Harimoto, file 25-93378FC. Counsel, you want to state your appearances for the record, beginning with People?
Your Honor, this is a special prosecution assignment for
Oh,
Alcona County.
that's right. That's with Miss Reed, and I see her. That's right. Hang on. All right, good morning, Miss Reed.
Good morning, Your Honor.
All right, we're calling the case of People v. Harimoto, file 25-93378FC. We have Elizabeth Reed for the people, Mr. Williams for the defense, and the defendant appearing. All parties are appearing by Zoom, and I'm here in the Pressfield courtroom, providing public access both in the courtroom and also online. And we are here for a docket call. And what I mean by that, Ms. Reed, is that I treat that as sort of like a jury status conference. Is the case resolved? Is it likely to, is it resolved? Is there any motions that are going to be filed? Is it ready to be placed on our trial docket? Or should we set it for another docket call if the parties are still in discussions? So, Mr. Williams, what's the status here, sir?
Thank you, Your Honor. I did speak with Ms. Reed this morning, and she did make an offer of criminal sexual conduct 4th degree with no other plea concessions was the wording. So I just want to be clear that was the offer. We intend to plead to the CSC 4. I would ask if the court could set this out for a plea date. I really haven't had much opportunity other than telling my client that the prosecutor did make the offer, but I want him to be very clear on what the consequences are. One thing that I have to look at, and I think because of the age, I do believe it will be a 25-year registry as opposed to the 15-year registry. So there's also some, and any motion work would just be either a sentencing memorandum I file, which isn't a motion obviously, or I know the prosecutor will object to it, but if I do file Holmes v. Trainee, she'll object to it. I don't have any leverage there because he's over 22, but I still may use as an opportunity just to educate the court on the events that took place or through the sentencing memo. But we do have a resolution. We do not intend to go to trial. This is not a case that would go to trial based off of the evidence and the statements that have already been made through confession. So that's where we're at, Your Honor.
Well, what I could do is schedule this for another docket call on January 5th at 11 a.m. I would allow Zoom appearances for that hearing. And if you want to use that as a plea taking date, that's perfectly fine. And I'm comfortable even taking felony pleas by Zoom if you want to do that. If you want to be in person for that, that's fine as well.
No, we'll plan on Zoom, and we'll plan on doing a plea by Zoom. I think that's appropriate, and obviously we'll be there in person for sentencing, but we could do that.
Okay, well, we'll set it for a docket call January 5th at 11 a.m. Zoom is allowed for all parties. Anything further from the people, Ms. Reed?
No, Your Honor, I just want to confirm, I do believe it's 25-year registration period.
Okay. All right, anything further from the defense, Mr. Williams?
No, Your Honor, thank you.
Okay, have a good day then.
You too. Happy holidays, you guys.
Thank you. All right, is this Mr. Chapman?
It is, Your Honor.
All right, this is People v. Wyatt Chapman, file 25-93379FH. Counsel, you want to state your appearances, beginning with People?
Morning, Your Honor. Zachary McClendon on behalf of the people.
Hey, good morning, Your Honor. James Gilbert here on behalf of Mr. Chapman.
All right, good morning. We're here for an arraignment. Have you had a chance to review the charging document with your client?
We have, and we will waive the reading.
And how does he wish to plead to its charge?
He'll stand mute at this time, and we are not requesting a forensic.
All right, so I will enter a plea of not guilty on Mr. Chapman's behalf. What would be the estimated length of trial?
Probably 2 days.
I agree, Your Honor.
All right, appropriate for docket call on January 5th at 9:50 a.m.
Believe it's appropriate.
All right, anything further from the defense?
Your Honor, we would request that the court would consider at this time, Mr. Chapman has gotten all his other matters in different counties resolved, that the court would possibly consider a bond reduction at this time. He does have extensive family in the area. And like I said, the items that are here are his sole focus at this point.
Hey, Mr. McLennan, I guess right now, just to confirm, the bond is set at 50,000 cash or surety, is that right?
That is correct.
Okay, Mr. McLennan, people's position?
The people would oppose a reduction in bond, Your Honor. He's a habitual floor offender. He's facing a 15-year felony. People obviously believe there's strong evidence to support a conviction in this matter, so we would oppose a change in bond.
I mean, I don't know anything about the facts of this case, but just looking at the charge itself, I'm not sure that there's an immediate threat to public safety. The bond is set pretty high under those circumstances. I do think maybe that was influenced if he had other matters pending in other counties and those taken care of. He does have okay, well, the priors are just a couple possessions and a maintaining. So his priors are not terribly troubling, even though the possession of methamphetamine is technically a high severity felony. It's not, it's a possession charge. Is there any failure to appear concerns for Mr. Chapman presently or in the past?
That's not.
Okay, I'm going to amend bond to a $10,000 personal recognizance bond with the
Thank you very
same
much.
conditions if there were any conditions.
Thank you, Your Honor.
All right, we'll see you January 5th at 9:50 in the morning, Mr. Chapman.
Thank you. Thank you, Your Honor.
Mr. Vogler, that brings us to People v. Mariah Keaton. Is she present?
I don't know. I've not seen her this morning.
Okay, well, we could pass the case. See if she appears while we're on our morning docket. About think the jail is gonna get Mr. Hoffman in the library. Is Mr. Stoneham here yet, or? Well, and that's an Attorney General case. All right, we might be a little bit ahead of ourselves here. Let's go off the record for a minute. Okay, so I hear that as not an unambiguous request for self-representation, but an expression of dissatisfaction with appointed counsel.
And withholding information.
All right, so under those circumstances, I would not consider that a valid waiver of the right to counsel. So Mr. Vogler will remain on the case. We're scheduled for your jury trial on January 22nd. Have witness and exhibit lists already been exchanged?
Yes.
Okay. All right, jury instructions and verdict forms 7 days prior. There'd be no need for further docket call then. Is that correct, Mr. Virgo?
Correct, Your Honor.
Correct, Mr. Vogler?
Yes, Your Honor. I would say this, that there could be, I would be meeting with the prosecutor. Some of their exhibits are video recording, body cams. There may be some, I guess, motion eliminates that I might want to file and have heard on January that.
Oh, the January 5th date?
Yeah, because
Okay.
unless, I mean, we may be able to reach agreement on redactions and things like that, or what should or should not come video.
You want me to just put it on for a docket call just so we can touch base on it then?
That's fine, Your Honor.
Okay. We'll put it on the January 5th for docket call at 10:10 a.m. And Mr. Vogler, you have a motion for bond reduction noticed up. Go ahead.
Your Honor, the only thing I would add to this is that I mentioned a delay between a July 1st preliminary examination date, that was the date it was originally scheduled, and it was adjourned to July 15th. That adjournment occurred over the defendant's objection. My recollection is that the district court found good cause to adjourn it. That's the only thing I wanted to speak of as in terms of the delays that have occurred in this case. Otherwise, I believe the 180-day is set to come up here very shortly, December 5th, I think it was.
Okay. All right, Mr. Wirgo, people's position.
Relative to reductions in general, Your Honor, he likes to run and he's facing certain conviction. I think that if he gets out, he's going to stay out.
No, you don't know that. I have an address here in Rogers City.
Yeah, and Mr. Hoffman, Mr. Vogler did provide that to us with Ms. Musek. All right, well, in this case, it's a charge of fleeing and eluding third with a habitual fourth. The court did quash one of the felony counts on defense motion, and then there's a misdemeanor charge as well. I think that the bond was set pretty high. What's it set at? Oh, it's at 75,000 cash or surety. And now there's a motion to reduce it under the court rule that he's going to be served 6 months in jail. So the court needs to reconsider a personal bond. Under these circumstances, Mr. Hoffman's got habitual fourth notice in this case. And these allegations involve some dangerous driving. And we do have trial scheduled just next month. If I wasn't able to get trial scheduled for, say, another 4 months, I think I'd really give some thought to, where we're at on bond here. But I think given that we've got trial in January, I'll deny the motion to reduce bond at this time. All right, so Mr. Hoffman, we're going to touch base on January 5th with any possible motions that your attorney may have. And then we're scheduled for a trial on January 22nd. All right, we'll see you then.
Ms. Cheek has arrived.
Call People v. Mariah Cheek, file 25-93358. And Mr. Vogler, when we were last here, you said that you had subpoenaed some financial documents. Have you received those then?
I have received, there have been 3 subpoenas put out, not at the same time. The last one was put out, but 2 of the bank subpoenas have come back. Not yet looked at the most recent one. The other one, which was to the owner of the alleged victim in this case, has not picked up service there. My suggestion to the court, my request really would be to set this matter for a spring trial date. My plan, I guess, will be to subpoena the gentleman to that trial with a request that he produce certain documents. I will come back, however, before trial and ask the court to give me an early return date on my document request. But at this point, any other way to do it.
Well, so help me understand, this is the complaining witness?
Well, it's the owner of the complaining witness. Yeah, it's a LLC that's the victim. He's the principal of that.
And you've sent a subpoena to that individual and they've not been served with the subpoena?
They have not read, it was registered mail, return receipt, has not been picked up. That went out before last year.
Mr. McLennan, what's your position with regard to the defense wants to get documentation from an owner of the complainant in this case? That seems like a very reasonable request, and that your office should provide some assistance there.
Your Honor, I would agree that we'll provide any assistance we can, and it is a reasonable and required request in this case.
Yeah. In fact, I'm going to direct that the prosecutor's office should assist with the service of that subpoena. Get a deputy to go serve him with that subpoena. Go get those records, have the police get those records for you. The defense needs those records. And Mr. Vogler, if that doesn't happen, we'll set it for a January 5 docket. I'll get you some trial dates today too. But if you don't have what you need, notice up a motion to compel or something. I mean, I think that's information that we could maybe. I don't know what the parameters legally are for the prosecutor's obligation to get those documents to you, but I'd be open-minded. And it sounds like Mr. Virgo agrees that this is reasonable, that what you're wanting is reasonable for you to obtain, and they'll provide some reasonable assistance with that. So if you can communicate with their office.
I will, Your Honor. It just said that I had always assumed that a subpoena from a defense attorney in a criminal case would have to be honored.
That would be, but first he's got to be served with it.
Yes.
So you would need to get him personally served.
I would, but then I was at the seminar last month, and all these really good lawyers are saying, no, you don't have to honor it. And the only way you can do it is get them subpoena to a trial date and get an early return on the subpoena production of those documents. So I don't know. But the bank responded, so I'm at least 2/3 of the way there right now.
Okay. What would be the estimated length of the trial then?
I thought we said 2 days.
Agreed, Your Honor.
Huh?
Agreed.
Okay. How about I could give you a Monday, Tuesday, March 16th and 17th. And I'll give each side 21 days to exchange witness and exhibit lists. And we'll come back for a docket call January 5th at 10:20. And Mr. Vogel, I guess I'll leave it in your capable hands to decide whether you want to file a motion to compel or whether you want to submit a trial subpoena and ask for an early return date, or whether the prosecutor's office is willing and able to assist you. And if you need any assistance from the court, you can notice up any motion at the docket call.
All right, thank you, Your Honor.
All right, anything further from the people?
No, Your Honor.
From the defense? Anything further from the defense? All right. All right, we'll see you January 5th at 10:20, Ms. Chief.
Thank you, Your Honor.
Is Mr. Bogner present?
Yep.
You want to come on up to a table? I've got Mr. Hartman. on Zoom. All right, up next, we've got People v. Michael Bogner. It's two file numbers 25-93375 and 93376 FH. Counsel, you want to state your appearances beginning with People?
Zachary McLennan on behalf of the people.
behalf of Michael Bogner.
Okay, we've got Mr. Hartman appearing by Zoom video. Mr. Bogner is present in the courtroom. We're up for a docket call. In these files, a couple possession cases, Mr. Hartman, what's our status here?
Your Honor, we're going to enter a plea. Does the court have the written plea agreement we submitted?
Not. Do you have a copy, Mr. McLennan? Okay, I've got, Mr. McLennan's providing me a copy.
Mr. Hartman, may I check the accepted box on the plea?
Yes.
Okay. All right, I have a plea agreement for Mr. Vogner to plead guilty to, in file 93375, the possession of cocaine, and then count 3, the unlawful plate, count 4, unregistered vehicle, the remaining charges, and the file in 93376, and the habitual fourth would be dismissed. Mr. Vogner, you want to proceed with that, please, sir?
Yes.
Would you stand and raise your right hand for me, please? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can be seated. So, Mr. Vogner, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So listen carefully. If you have a question, go ahead and ask. I'm happy to answer it. If you need to talk to Mr. Hartman some more, you just let us know and we can make that happen. Do you understand that?
Yeah.
All right, now I have to advise you the maximum penalty that you can face. Count 1, possession of cocaine less than 25 grams is a felony. It's punishable by a maximum of 4 years in prison and or a $25,000 fine. Count 3, unlawful plate is a 90-day misdemeanor and or $100 fine, unless it was a commercial. Was this a commercial vehicle?
No.
No.
90 days and or $100 fine. Count 4, operating an unregistered vehicle is again a 90-day or $100 fine misdemeanor. Do you understand the maximum penalty, Mr. Vogner?
Yes.
Are you on probation or parole anywhere?
No.
Were you on bond for any other felony cases at the time of this incident?
No.
Do you understand if you enter a plea, you won't have a trial and you'll be giving up the rights that you would have had at trial?
Yes.
I want to remind you of the more important of those trial rights. You'd have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and you could question them. You'd have the right to present witnesses in your own defense and have me order them to show up. You'd have the right to testify in your own defense or to remain silent and not have your silence used against you in any way. Do you understand those rights?
Yes.
Do you have any questions for me or Mr. Hartman about any of those rights?
No.
Do you wish to give up those rights and enter this plea today?
Yes.
If I accept your plea, you give up any claim that it was caused by threats or by promises outside the terms of the plea agreement. Do you understand that?
Yes.
Also, when you plead guilty, you give up the right to appeal. And if you wanted to appeal to a higher court, then you'd have to seek permission to appeal. You would do so by filing an application, but the types of issues you could raise on appeal after you plead guilty are very limited, much more limited than if you were convicted at a trial. Do you understand that?
Yes.
Other than the plea agreement that do you understand the terms of that plea agreement as I set forth?
Yes.
Has anybody promised you anything else?
No.
Has anybody threatened you in any way to make you plead guilty?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead to the charge of possession of cocaine?
Guilty.
How do you wish to plead to operate or displaying on a vehicle and an unlawful plate?
Guilty.
And how do you wish to plead to operating an unregistered vehicle?
Guilty.
So, Mr. Bogner, back on July 5th of this year, were you in Presque Isle County?
Yes.
Were you operating a gray Chevy Impala on a public highway?
Yes.
Was that vehicle properly registered?
No.
And did you have on it displayed a registration plate for a different vehicle?
Yes,
And was this your vehicle?
yes,
So you knew that state of affairs that it had the wrong plate on it?
yes,
Okay. And did you have some contact with law enforcement? Police
yes,
pull you over or something? Okay.
yeah,
And then were you found to be in possession of cocaine, controlled substance?
yes,
Did you know that you were in possession of that substance?
yes,
Do you have any lawful authority in the state of Michigan to possess that substance?
no,
Mr. Hartman, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. McLennan?
Yes, Your Honor.
Mr. Hartman, are you aware of any other promises, threats, or inducements?
I am not.
And do you believe I've fully complied with the requirements of MCR 6.302?
Yes, sir.
Mr. McLennan, do you agree on both those questions?
I do, Your Honor.
All right, Mr. Bogner, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I hereby accept your plea. Mr. McLennan, any objection to continuation of bond?
No objection.
Bond will be continued, and we can schedule sentencing for January 5th at 10:30 in the morning.
Your Honor, I'm checking. Seems to be a popular day.
That, since I only do one motion day a month over here, I'm going to ask you to do your best to make that date work.
I can do that, Your Honor.
Okay. All right, so Mr. Bogner, I'm going to ask you to see Agent Lesky briefly and maybe just get a card from her. You'll have to contact her to schedule an interview for her to write a report for me with some recommendations so I know more about you and your circumstances and we can make a good decision on January 5th, all right? You have to cooperate with that process.
Good.
Anything further, Mr. Hartman, from the defense?
Your Honor, what was the time on January 5th?
10:30 in the morning.
Your Honor, well, nothing further.
Okay, anything further from the people?
No, Your Honor.
Okay, you're all set. Have a good day, Mr. Hartman. Have a good day, Mr. Bogner.
Do you need the vice and right form signed?
Oh, you know what? I went over them with you. So if you want to hand that to the bailiff, we'll put it in the file.
All right, I haven't signed these yet.
Oh, you don't have to sign them then. I went over them with you on the record. So you're all set.
Oh, okay, so I don't.
Okay.
Morning.
All right, we're back on the record, and up next we have People v. Manson Stoneham, file 25-93369 FH. Counsel, you want to state your appearances, beginning with People?
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Good morning.
Morning.
Your Honor, Mike Vogler, just here temporarily with Mr. Stoneham.
Okay, I do see Mr. Green. Mr. Vogler's here with Mr. Stoneham today, and he's tendering a substitution of attorney. It's being shifted, I think, to the other attorney that's in the indigent defense.
That's correct.
It's a shifting to another assigned counsel, James Gilbert. So any objection to us putting this over to the January docket, Mr. Green?
No, not at all, Your Honor.
Okay, we'll set it then for January 5 at 11 a.m. And I'd authorize a Zoom appearance for the Attorney General's office.
Thank you, Your Honor.
Thank you, Your Honor.
All right,
Your
we'll
Honor?
see you then. Yes.
May I say one thing, and I say this on behalf of the defendant. He's been making very good payments up until the beginning of November, showing a lot of good faith, and that gives us hope we can have an offer. We haven't received any payments in the month of November, though. And I would strongly recommend that he continue to make significant payments so we can move forward with the offers we've made.
Okay, very good. And Mr. Stoneham, you can discuss that with Mr. Gilbert as well. And these are strange cases in several respects, and the most efforts that you can make to show good faith is going to be certainly in your interests.
Your Honor, can I speak?
You may, but they don't feel like you have to.
Well, I just want to say that last week I did pay $1,000.
Okay.
I do have another $1,200 check right here for him, and I got another $1,000 on the way.
Okay, so Mr. Green, Mr. Stoneham's indicated he just made a payment last week. He's got a check in his hand today, right now, that he's going to process through, and he's got another payment next week that's going to be made.
That's great news, sir. Thank you.
Okay, you have a good day, Mr. Green.
You too, Your Honor.
Right, and that brings us to sentencing and People v. Kathy McCon, file 25-93377 FH. Counsel, you want to state your appearances, beginning with People?
Jeremiah Buffalo, we're on behalf of People.
Lauren Mattis for Ms. McCon.
All right, good morning, and we're here for sentencing on charge of operating while intoxicated. Third offense, a 5-year statutory maximum. There's a guideline range of 0 to 17 months. And Ms. Madison, have you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor.
Do you have any additions, corrections, or modifications to request to the factual information in the report?
Just as to one of the offense variables, Your Honor.
Okay, Mr. Wirgo, any additions, corrections, or modifications to the factual information in the report?
No, Your Honor.
Okay, and scoring challenges, Ms. Madison, you said you had a scoring challenge here?
Yes, Your Honor. In reference to offense variable 12, the assertion that Ms. McCon committed contemporaneous felonious conduct in this matter, I think is untrue. There were additional felony charges of obstruct, resist assaulting law enforcement. Following a review of the body cam, those charges were dismissed by plea and for good reason. What I saw on the body cam was a woman who was obviously drunk, distraught, upset about being taken into custody, but was not resisting, obstructing, assaulting anybody. I would ask that OV12 be scored at 0.
Mr. Wirgo, People's response?
Your Honor, this one is pretty open to interpretation, admittedly. If it is resisting, it's on the bottom of the level. She sat on her living room floor and cried that she didn't want to go to jail. That's the level of resisting.
read the description of the offense narrative again. All right, and on page 3, under the agent's description of the offense, it indicates that after the defendant was advised she was under arrest for operating while intoxicated, a deputy grabbed her right arm and that she pulled her arm away and said, "Spin, spin," and tried to walk away. Sergeant gave her verbal commands to stop resisting, and then they grabbed her arms again and handcuffed her. I think that would be sufficient for resisting and obstructing. That would be a separate act from the drunk driving. So that'd be a separate felonious criminal act. However, the pulling her arm away from Deputy Smiley and the failing to obey the commands of Sergeant McClelland were all sort of occurring simultaneously as one action, I would think, so that although I would not sustain the objection in full, I do believe that OB 12 should be scored for contemporaneous felonious criminal acts. However, I believe there's only one felonious criminal act against a person as a crime against a person, that being one count of an R&O. Well, there may be, again, the case law in OB 12 counsels us that we're not looking at the number of counts, we're looking at the number of separate felonious acts. And here I perceive one. So I would score OB 12 at 5 points. That would take it from 25 points to 20 points. Are there any additional defense scoring challenges?
No, Your Honor.
Any scoring challenges from people?
No, Your Honor.
Okay, so let's see. So that brings, we're on the E grid. And that brings us from OB level 3 to OB level 2. So that instead of 0 to 17, we are at 0 to 11. Is that correct, Ms. Madison?
That is my understanding, Your Honor.
Mr. Virgo, is my math right?
Seems so, Your Honor.
All right. All right, Ms. McCollum, anything you want to say on behalf of your client?
Thank you, Your Honor. Judge, I would just ask that the court take judicial notice of the contents of the pre-sentence investigation. Ms. McCann is a 58-year-old woman who's had incredible number of challenges in her life. One of those challenges is substance abuse and addiction. And she stands before us today as a sober woman. Obviously, that is in large part due to the fact that she's been incarcerated for a number of months. But she did complete over a month of inpatient treatment at Harbor Hall, which, though she left on not the best of terms with them, she was asked to leave in regards to some behavioral issues. None of those issues had anything to do with whether or not she was sober. She remained sober that entire time. And I do think there's a huge amount of accomplishment for her in that. Additionally, she has 177 days of credit time per the PSI. And she understands at this point the importance of remaining sober. She has a plan for her release. She intends to, unfortunately, stay with her ex-husband for a little bit until she's able to access housing independently. We do believe she will be able to do that because she has a good amount of money in the Harris Law IOLTA from her divorce settlements. We do believe she will be able to quickly obtain housing and get into AA and get on Social Security disability and live an independent and sober life. We would ask that the court take her 177 days of credit time and time served in custody sentence, and then give her a 2-year probation sentence moving forward with alcohol monitoring and mandatory outpatient treatment. Thank you, Judge.
Thank you, Ms. McCon. It's not required that you would say anything today, but you're welcome to. Is there anything you want to tell me or no?
I just want to apologize for my behavior and let you know that I'm going back to AA.
Okay, thank you. Mr. Wargo, any recommendations from the people?
Your Honor, Ms. McCon received the benefits of a plea bargain and some very good representation, reducing her guideline range. We do note that she has had very bad luck with her rehab facilities and doesn't appear to be engaging with them on the best of terms. As such, Your Honor, we would ask that the court sentence her to the high end of the revised guidelines and then wish her well on future endeavors in sobriety.
Thank you, Ms. McCon. If you please stand for the court sentence. Ms. McCon is 58 years of age. She has some prior felonies, 3 prior felonies, 7 prior misdemeanors. Most concerning, of course, is the pattern of operating while intoxicated convictions. She has one in 2008 in Indiana, one in 2011 in Indiana, and then one in 2020, looks like was with me. And then that time I gave her a year in jail and probation. And now 5 years later, we're back again for a true 4th conviction. Also troubling is in the 2020 case, she had continued to drink on bond, resulting in a bond revocation. And in this case, she again continued to drink on bond, resulting in a bond revocation. So I do think there's a real concern about Ms. McCon's level of involvement in her recovery, and the pattern of drinking and driving. Those facts aren't even adequately taken into account in the guidelines, Ms. McCon. And were it not for a sentence agreement for a 12-month cap, I would seriously consider sending you to prison today. I would. And here's one big reason for it. Last time you saw me for repeat drunk driving, I gave you a year in the county jail. How many times do you think you get that outcome? You appear in front of me for repeat drunk driving again, and your attorney wants me to give you less time than what you got last time. No, you're going to get the same amount. And that's me refraining from doing what I think I really should do, which is to send you to prison. But you've got the sentence cap. I promise you, if you appear in front of me for drunk driving again, I will send you to prison.
Sure.
You deserve it today. You will certainly receive it next time. So I am going to place Ms. McCon on probation for 2 years, subject to the terms and conditions listed on the pre-sentence report. I want to highlight a couple of those that you have to complete. Substance abuse treatment when referred by your agent. There's 480 hours of community service. Crime victims assessment of 130, 350 in court costs, 250 in an OUIL reimbursement. You have to comply with DNA testing and pay a $60 fee, $68 in state cost, and there's a monthly supervision fee to the Department of Corrections. And I am going to order that you serve 12 months in the Presque Isle County Jail with credit for 177 days previously served. That is a 1 month upward departure from the advisory guidelines of 0 to 11 months. My reasons for imposing that is that this is a true fourth conviction. We have a pattern of drunk driving. We have a pattern of bond violations. In the 2020 case, she received 12 months in jail. And I think with these types of cases, Ms. McCon, we ratchet up, we don't ratchet down. So you're lucky to walk away with a sideways sentence, this same as what you got last time. So that's the reasons for the sentence. You can appeal if you would. Oh, I'm sorry, you are, a couple extra things. The rehabilitative goals of this probationary term are those set forth in the pre-sentence report at page 2. You are eligible for early discharge from probation at the halfway point if you've successfully completed any programming you've been sent to. So we're going to hand you a piece of paper explaining that process. Also, you can appeal if you wish by filing an application to the Court of Appeal to challenge your conviction or my sentence or both. If you wanted a lawyer appointed and you qualified, you'd have to request that within 6 months. We're going to ask you to initial one copy of that form so we have a record that we gave it to you. And the other one is for you to fill out if you want to take an appeal. Within 24 hours of your release, you have to contact Agent Lesky. And good luck with getting back in on a path of recovery, Ms. McCon. Okay.
Thank you, Your Honor.
All right. Have a good day, Ms. Madsen.
Thank you, Your Honor.
Go this way. Let's go off the record. Okay.
Yes, sir, it is. Christine Diana Bennett.
All right, this is People v. Christine Bennett, file 25-93364FC. Counsel, you want to state your appearances, please?
Zachary McLennan on behalf of the people.
Honor Mike Vogel, I represent Christine Bennett.
Great, and we're here for a docket call. What's our status here, Mr. Vogel?
Your Honor, so the forensic center did complete their evaluation, and I have a copy of it. I have engaged a forensic psychologist to conduct an independent interview or evaluation, I should say. He will not be able to see her until January. He's in the process of looking over material. I would ask for a February docket call on that.
All right, any objection, Mr. McLennan?
No objection, Your Honor.
And then, of course, if that's on the issue of criminal responsibility.
Correct.
So that'd be an affirmative defense at trial then, but I suppose you'd certainly want the people to have the benefit of your experts' opinion with regard to any possible resolution as well? Is that fair to say?
Well, I don't know. I don't know how this thing will end up.
Like, I guess I'm asking, should we just schedule this for a trial as well, or you want to just get this step done?
I would like to get this step done. We also, have looming in the background, the Michigan Supreme Court
Diminished
decision.
capacity decision. Okay, gotcha. All right, so we can continue this then to February 2nd at 9:10 a.m. Any further from the people?
No, Your Honor.
From the defense?
No, you are.
All right, Ms. Bennett, we'll see you then.
Thank you.
All right, up next, we've got People v. Zachary Maynard, file 24-93338FH. Counsel, you want to state your appearances, please?
Jeremiah Buffalo, we're on behalf of the people.
Brian Clinton, on behalf of Zachary Maynard.
All right, and we're here for a docket call. We have trial scheduled for late January, and also Mr. Clayton, I received your motion to sever. We still on for trial, and if so, go ahead and argue your motion to sever.
Well, so I'll preface this by saying I was gone Tuesday, Wednesday of last week, and obviously the courts were closed on Thursday, Friday. On the 26th, which was a Wednesday, I was in Nashville, Tennessee. I did receive today an email from Mr. Wergo communicating an offer. And just the message said that the scanner was broken, but I have an email of the offer. But in the offer, and this is what confuses me, the offer indicates it has to be accepted by January 5th. I just got it today. I don't have anything in my paperwork that would indicate there's a docket call on January 5th. I thought today was the plea and motion cutoff date. So I guess I'd like to clear that up first. Do we have a final docket call on January 5th, or is it today?
We don't. There's not one scheduled in this case on that date. The prosecuting attorney's office was probably just picking that because I do have a motion day here on January 5th. And if the case were resolved on that date, I think we would not have yet sent out jury summonses for the January 28th date by January 5th. So they probably just picked that date as a good date for a deadline for that. So
good. Then I'm not losing my mind. That's always a good thing to find out on Monday morning. I'm not crazy.
All right. Am I reading that right, Mr. Wergo?
Excellent read, Your Honor.
Okay.
All right.
All right. So where's that
issue?
Does that mean that we want to argue your motion today, or do you want to argue it on the 5th if it's not resolved?
Either way, I never received a response from Mr. Wergo on the motion. I don't know if it means that he agrees with me, or if he doesn't agree with me, or if he does, there's nothing to argue, I suppose.
Mr. Wergo?
Your Honor, I would be seeking to introduce other acts evidence under 404B that would, one or the other, Your Honor, kind of. If we sever the trial, then the court obviously wouldn't allow me to do that. But if the court allows me to bring in the 404B, then the severance would have no effect, essentially, because I would be seeking to introduce the different act, the separate victims.
What
can I ask you one question about this? Just procedurally too, Mr. Clayton's motion seemed to describe that there were 2 counts, but I have an information that has 3 counts. Where are we at with the number of the? Why am I confused about the number of charges?
Because the court shouldn't be confused. We discussed this. So there's 2 counts that allegedly occurred in Presque County. 1 count allegedly occurred in Montmorency County. We've already vetted that the court only had jurisdiction when this case was initially charged as a juvenile case, because the location of the respondent at that time was in Presque County, so jurisdiction would have been appropriate in Presque County.
That's what I thought, but I don't know that we've ever gotten an amended information or anomaly of any of the counts. So the operative charging document in this file, I think, is still a 3-count information. Is that right, Mr. Wergo?
It is presently, Your Honor, but Mr. Clayton is right. It should be the 2. The one is alleged to have happened in Atlanta, Michigan, which should be outside.
So I've got, the 3 counts. Which of the 2 counts are surviving that issue? Is it?
Well,
Your Honor, I'd like to, I don't want to just shoot from the hip on that. I want to double check on it. I do know that count 3 will be surviving. As to counts 1 and 2, I don't want to shoot myself in the foot and dismiss them all.
Okay.
And
all right,
and since one, and then I would say that since 1 and 2 are identical charges, let me make sure they are.
Yeah, 1 is based on age, though, and 1 is based on force or coercion.
And I can't tell. I'm looking at the felony information, and my guess is count 1 would be the one that doesn't survive, because that's most likely the one that occurred allegedly in Montmorency County. So really, the motion is based on count 2 and count 3. Count 1 would just.
Well, let me ask you this way. Counts 1 and 2 involve the same complaining witness?
Correct.
Is that right?
I do believe so, Your Honor, yes.
That's true.
And yeah, okay. All right, well, I guess, Mr. Clayton, do you want to go forward on your motion to sever today, or do you want it renoticed for January 5?
Well, I didn't plan on supplementing my motion with any kind of argument. I think the motion speaks for itself with regards to applicability of the court rule, MCR 6.120 parent C. So it's a defense motion. I wouldn't need to supplement my written brief with any kind of oral argument. I think it is outlined fairly well.
Okay, Mr. Wergo, what's the people's response to that?
I concur with Mr. Clayton's analysis of the law. I think the decision that the court needs to make is whether the other act's evidence relative to victims who are asleep but not extremely intoxicated, and a victim who is extremely intoxicated, sufficient enough in nexus to establish a pattern. And if so, then if that other act comes in, it would be these separate charges, Your Honor. So then bifurcating the trials wouldn't make sense.
Well, that's kind of hard to do when, I mean, there would have been no reason for you to file a 404B notice. So I understand that, but I don't have the benefit of briefing on, whether it would meet the requirements of 404B. I will say, based on the severance and joinder rules, one involves, do I have it correct that one of these charges involves a minor complainant and the other one is an adult complainant? Or are both of the surviving charges, were they above the age of consent at the time of the incident?
Your Honor, I do believe it is one of each.
Okay. Yeah, so one is a minor complainant with whom the defendant had a relationship, and one is an adult complaining witness with whom he did not have a relationship. One of them involves an allegation that the victim was incapacitated by being asleep. One involves force or coercion due to, well, they're both charged as force or coercion, but not incapacitation, frankly. They're both charged as force or coercion, but they according to the defendant's motion, do involve substantially different factual circumstances. Because at least one of the complaining witnesses is not a minor, then that wouldn't trigger the statutory other acts procedure where I can say, well, gee, the evidence of both of these cases would be admissible in the separate trials in any respect, so therefore severance doesn't make any sense. I don't think that's so clear cut because the statute doesn't apply given that these are not both sexual acts against a minor. The question of whether they're related, the People v. Wisniewski case in 2025 did say that you can join cases involving multiple complaining witnesses as long as they're related. And in that case, they were related to the extent that they involved a series of connected acts amounting to parts of a single scheme or plan. In the Wisniewski case, both the victims were very young when the abuse began. The defendant exploited personal relationships of trust, and his specific method of sexually abusing the girls was similar. None of those facts are really present here. And although the prosecutor would still be able to file another X notice under 404B, and we'd have to, I guess, address if there's any objection to that, I can't say for sure that they would be admissible under 404B. The common scheme or plan elements of 404B require some striking similarities. And here, at least based on the facts alleged in the motion, I really don't see those. So I would find under the court rule that these offenses are not related for purposes of joinder, and I would grant the defense motion to sever. And Mr. Klain, you can present an order to that effect. We should probably specify in the order which counts are going forward.
I think it was anticipated if this does go to trial. And once again, I've not seen the written plea offer as of yet. I'm sure I'll see it this week. But if the plea offer is accepted, which I just haven't had enough time to even look at it, but if it is, then it kind of moots the argument because it resolves all three counts. But I would think that if this went to trial, what would happen is it go to trial, since the court has granted the motion for severance, it would go to trial on count 3. I believe.
Well, that was my next question is Mr. Wergo, severance being granted? This is scheduled for a 3-day trial on January 28, 29, and 30. The motion being severed, I have 2 questions. One, which count do you want to try in January? And number 2, do we need 3 days, or can this be a 2-day trial then?
Count 3, Your Honor, and it's a close call on that 3rd
So you
day.
think we should still leave
it
for 3 days? Mr. Klain, you have any objection to that? Just still leaving the trial scheduled as 3-day?
I don't, because and not for different reasons than Mr. Wergo articulates. The reason I don't is because I don't object to it is because I find that jury selection in CSC trials can tend to be a little bit longer, just because emotions are high and there's people have strong opinions on this kind of cases, so I don't mind it. I certainly don't think, in my heart of hearts, the prosecution on his witness and exhibit list endorses 19 witnesses. I doubt that there's going to be 19 witnesses called for a single count information. But I don't know what the amended witness list would look like. It's not going to be 19, I would guess. But I think keeping on for 3 days is smart, but I also agree with at least the spirit of Mr. Wirgo's email that we should look at this on the January 5th date. Because I'm being perfectly candid with the court. I may, in talking with my client, tell him that I think this is a good resolution to the case. I just have not had the chance, having just got back to Michigan, well, essentially yesterday. It worked a little bit, but I didn't see this until today, so I really haven't had the chance to look at it. But it very well could resolve it. So if we could docket it for January 5.
Okay. All right, well, here's what we'll do. The motion to sever is granted and count 3 will be tried first and separately. Mr. Clayton, you can submit an order to that effect as the prevailing party. We'll leave the trial scheduled for 3 days on January 28, 29, and 30. We will come back for another docket call on January 5th at 11:10 a.m. And that'll be a plea cutoff date. And then, Mr. Wirgo, I guess the court rule allows a certain time frame for your filing of other acts motions, and so I'm not going to shorten that for you, but I would encourage you to consider filing it sooner rather than later. And that way, if Mr. Clayton has an objection to it, he could file that and notice it up, and we could sort that out on the 5th instead of trying to sort it out while we have a jury waiting.
Actually ashamed I didn't have it for you for today, Your Honor.
Okay, no, that's no problem. All right, anything further from the people?
No, Your Honor.
Anything further from the defense, Mr. Clayton?
No, sir, we all set.
Okay, you have a good day.
You as well, thank you.
All right, are you Ms. Dockstader? Can you hear us down there, Alicia?
Yeah.
Okay. All right, this is People v. Alicia Dockstader, file 24-93008FH. We're here for probation violation hearing. Mr. Vogler is in the courtroom for defense, and defendants appearing by video from the Prescott Jail. Mr. Vogler, what's our status here?
Your Honor, so the non-technical violation, the case that underpins that, this Dockstader is represented by another attorney. It's my understanding that the preliminary examination on that case was waived last week, so it will I guess be before you in January for arraignment on that date. I would just ask the court to continue this probation violation until
Any objection, Mr. McClellan?
No, Your Honor.
Mr. Wirgo, okay. All right, we'll continue the probation violation hearing then to January 5th at 9. I'll put it at 9 a.m. because that's the arraignment time slot, so that we'll see both cases at the same time and see what we're doing then. All right, we'll see you then, Ms. Dockstader. Mr. Gilbert, you have Michaela Hayes present.
Ms. Hayes is ready, and Mr. McGrath is mine also.
Oh, I'm sorry. That's right. Mr. Vogler pulled that. All right, Mr. Vogler, that concludes your matters then?
Yes,
all right, have a good day. Yep. Thank you for the council, the conference and chambers on the other matter, and I'll let you know.
Yes, I appreciate you, Your Honor.
All right, People v. Michaela Hayes, file 25-93360. Council, you want to state your appearances, please?
Zachary McLennan on behalf of the people.
And James Gilbert here on behalf of Mr. McGrath. I'm sorry, wrong file. Miss Michaela Hayes standing to my right.
All right, and we're here for sentencing on a charge of maintaining a 2-year high court misdemeanor in possession of methamphetamine, a 10-year felony. The advisory guidelines are at 0 to 11 and 0 to 17. Have you had a chance to review the report and recommendations with your client?
Yes, we have had a chance to go over it. We do have a challenge to scoring, but other than that, no additions or corrections.
Okay, and Mr. McLennan, any additions or corrections to the report from the people?
No, Your Honor.
Okay, your scoring challenge, Mr. Gilbert?
Your Honor, just the one, and I don't believe it changes the grids, but I just wanted to point out she's currently scored on both of these on OB 15 for 5 points. my understanding that would, to get those 5 points, that it would have to constitute trafficking, which would mean that the items would have to be then being sold so for further distribution. And my understanding or the police report in that is that items were sold to a CI or to another individual, but there was nothing in the reports that I saw that that individual intended to distribute.
Okay, Mr. McClung, response?
Your Honor, when I reviewed OB 15, I was reviewing for the offense involving delivery of methamphetamine. And so I thought it was properly scored at.
Yeah, the statute does allow for the scoring of 5 points. It says the offense involved the delivery or possession with the intent to deliver marijuana or any other controlled substance or a counterfeit controlled substance, or possession of controlled substance or counterfeit controlled substance having a value or under such circumstances as to indicate trafficking. From the statutory language itself, the modifier having a value or under such circumstances as to indicate trafficking, it's unclear whether that would apply to the entire sentence or only to the last part, the possession. The Michigan Supreme Court, in a published order, I don't remember the case name, did limit that modifier only to the possession part. So it would be scored where the offense involved possession under such circumstances to indicate trafficking. Here, there would be no circumstances indicating trafficking, which would be delivery to a person for further distribution to others. However, I agree with the prosecutor that both of these sentencing offenses involved, there were 2 controlled buys. So the offense, it's not limited to scoring it for delivery sentencing offenses, but it says where the offense involved the delivery. And here, both of these are pled down from controlled buys. So both of these sentencing offenses did in fact involve a delivery. And the Supreme Court's interpretation means that the trafficking limiter doesn't apply in that circumstance. So I would overrule that objection and leave OB 15 scored at 5 points for both counts. Any other scoring challenges from the defense?
None, Your Honor. Thank you.
Any scoring challenges from the people?
No, Your Honor.
All right, Mr. Gilbert, anything you want to say?
Your Honor, with her scoring, and I do believe this is a situation where Ms. Hayes, her and her husband or significant other got wrapped up in drugs, and she does need to address these issues. We're in support of the recommendation. We'd ask for a term of probation so that she can address those things. Ms. Hayes has been nothing but a joy to work with since I was assigned to this case. From day one, she acknowledged she had culpability in this case, and what she had done was wrong, and that she needed to address these issues. And so I would ask that the court follow the recommendation, put her on probation, and hopefully she can get any types of addictions under control. Thank you.
Thank you. Ms. Hayes, you don't have to say anything today, but you're welcome to. Is there anything you want to tell us? Or okay, Mr. McClendon, any recommendations?
Yes, Your Honor. Defendant's 25 years old and has 2 prior misdemeanors, no felonies. She's young, and it looks like she's completed some inpatient rehab and tested negative for drugs in November. The young mother with kids, and the plea and the delay was structured in this case to give her a chance to be a good mom to those kids and succeed at life and help them succeed. So, Your Honor, I think the recommendations are appropriate, and the people support them. Thank you.
All right, thank you. Well, Ms. Hayes, this is a very serious case involving, some controlled buys, and, I'm sure you're just as aware as everybody else that your codependent got a prison commitment in this, and you're just as involved as he was here. And so you should be very thankful to the efforts of your attorney and to the good graces of the prosecuting attorney that you also aren't going to prison today. I think given the family circumstance, there's the CPS case that's ongoing. You did complete the inpatient treatment. I think under all those circumstances, as well as what's laid out in the pre-sentence report, the plea agreement calls for you to delay your sentence for up to a year. And if you successfully complete probationary terms during that delay, the possession charge will be dismissed and will be at sentencing on the maintaining charge a year from now. I think that is appropriate under all these circumstances. So I'm going to delay your sentence for a year, and during that delay, place you on a probationary term supervised by the Department of Corrections, subject to the terms and conditions listed on pages 2 and 3 of the pre-sentence report, including outpatient or residential substance abuse treatment when referred. They include a crime victims assessment of $130, court costs of $350, $136 in state cost, comply with DNA testing and pay a $60 fee. There's a monthly supervision fee to the Department of Corrections. This is a statutory delay of the sentence. So we're not going to give you your appeal rights right now, and you're not eligible for early discharge from that probationary term, because legally what we're doing is we're just postponing your sentence for a year, putting you on probation in the meantime, seeing how you do. If you do well, then we'll come back for sentencing only on the maintaining charge. Okay. If you violate terms of your probation, including getting new charges or not complying with treatment, then we'd come back early for sentencing on both counts. Do you understand that?
Yes.
All right. And Agent Lesky, do you want her to stick around to talk to you today?
I'm just gonna give her a sheet to come see me.
Okay. All right. So go stop by and get a note from Agent Lesky, and then you have to report to her. Okay. Okay. Good luck to you.
Thank you.
All right. Let's go off the record for a second. Probation. Did you, on or about September 2nd of this year, use the controlled substance methamphetamine?
Yes, sir.
And also, as part of your probation, were you ordered not to violate any laws of the state of Michigan?
Yes, sir.
And in violation of that, on or about September 2nd, did you operate a motor vehicle while under the influence?
Yes, sir.
And did you face a criminal charge for that?
Yes, sir.
All right, Mr. Gilbert, are you satisfied with that factual basis?
I am. Thank you very much.
McClellan?
Yes, Your Honor.
Mr. Gilbert, are you aware of any other promises, threats, or inducements?
I am not.
Mr. McClellan?
No, Your Honor.
Mr. McGrath, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense, or that you have violated your probation. Therefore, I accept your plea of guilty to violating your probation. And I think I'll have this referred for preparation of a probation violation report. Did you enter a plea? It was a misdemeanor plea in Sheboygan County then? What's the sentencing date, Tim?
Actually, it was immediate sentencing because he already had enough jail credit.
Oh, gotcha. Okay. All right. Well, I think I do want to ask for a probation violation report. I guess I don't know. As I sit here today, I don't have a firm opinion in my mind about whether I want to revoke Mr. McGrath's probation and what kind of sentence I want to consider. So I think we'll schedule this for sentencing on January 5th at 10:40 a.m. And Mr. McGrath, you'll have to cooperate with any interview by DOC so that they can write a recommendation about what we ought to do here.
Yes, sir.
Anything further from the defense?
No, Your Honor. Thank you.
From the people?
No, Your Honor.
Okay, we'll see you January 5th at 10:40 a.m., Mr. McGrath.
Yes, sir. Thank you.
Then that brings us to People v. Joshua Pritchett. File 25-92370. And Mr. Gilbert, what's our status here?
Your Honor, the prosecution has presented us with a plea offer, which is very tempting to my client. However, there is a substantial restitution amount, and we're asking just so my client can attempt in the next make sure he can satisfy that. We're asking if you could possibly put this on your February docket, and hopefully we can have it resolved at that time, and any restitution matters can be resolved.
Any objection to that, Mr.
No, Your Honor.
All right, well, let's put it on February 2nd at 9:20 a.m. All right, Mr. Pritchett, we'll see you then, sir.
Okay, thank you.
And that is to people be Tiffany Gagnon.
I can make it.
Toby Gagnon, file 5-93371FH. All right, counsel, you want to state your appearances in this matter?
Zachary McLennan on behalf of the people.
And Your Honor, James Gilbert here on behalf of Tiffany Gagnon.
All right, and we're here for a docket call, and also we did a show cause for Ms. Gagnon's failure to appear last time we were here. What's, I guess, how do we want to proceed on that?
Well, I guess I addressed the show cause first, Your Honor. I did talk with Tiffany, and she told me that she did have the wrong date and time, because she was also in the Sunrise Center at that time, and that they'd given her the wrong time to be here. I can tell you that when we left court, Sheriff Brubaker assisted me in making contact with her, and she immediately was in contact with me, saying she didn't know about it, and it was nothing that she was trying to hide. And so I would ask if the court could possibly set aside the show cause.
Mr. McLennan, any objection or different information about that?
No, Your Honor, she's otherwise been reliable.
Okay. All right, I'll dismiss the show cause, and she is present today. So in terms of docket call, where are we at on that?
Your Honor, that hasn't been resolved. However, she is doing very well from what I understand, and I think that would probably affect what the prosecution wants to do. I believe she's successfully completing inpatient and is residing with her mother and doing fine. So yes, when her and I talked over the weekend, she is back trying to get her GED, I believe.
I'm maintaining all A's,
All right, well, any objection by putting it to the January docket? All right, I can do that, but I guess I'll say I disfavor using our pretrial system to just have sort of this pseudo probation, because she doesn't have the benefit of a probation officer and supervision. So if we know what we're offering, let's get her on supervision and let her do these things well on probation. So if if we're not resolved in January, we should probably be setting trial.
I understand.
Because on bond, they're left to kind of white knuckle it on their own efforts. And I much rather, if somebody's wanting to make changes, have the benefits of a probation agent that can connect them with services.
We will have the matter resolved by January.
Okay, so we'll come back on January 5th at 10:50 a.m. And that concludes our morning docket. Be adjourned.
Thank you very much.
Garrett Hughes.
That's it for today, everybody. Now, everybody, I broadcast every day at 3 o'clock p.m. Central Time, 4 o'clock Eastern Time. And we bring courts and court cases. That's what my passion is on this channel. Again, I would like to welcome all the new subscribers to this channel. Thank you for your support. If you like this content and you're not a subscriber to this channel, please consider subscribing to this channel and helping this channel grow. So that's it for today. You all have a wonderful evening. Cha-cha and ta-ta. Ciao, 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 and ta-ta. And I will be with you guys. I will see you guys tomorrow.